I opened the work session for the Children and Family Law Subcommittee that is going to be considering House Bill 499. The court shall admit any evidence or testimony in any form which the respondent believes will be favorable. And 475, the judge shall follow the rules of evidence in admitting items into evidence. They're very similar bills, so my thought is to proceed with a general discussion on rules of evidence and then break it out into the two particular bills. Let me start with an opening remark and then we'll turn it over to anybody else on the work group who wishes to share. Just a reminder that this is a work session, not a hearing. Therefore, all of the pink cards that people would like to sign in on are in my pocket, and you don't get one. We can occasionally admit someone to answer a brief and technical question if we so desire, but it's not a hearing with people giving evidence. We've heard a lot of evidence and a lot of testimony indicating that some judges seem to be way too broad in their discretionary powers. And in fact, a wonderful book, it should be on the bestseller list, called New Hampshire Court Rules Annotated Rules of Evidence. The Chief Justice gave me one of these a couple months ago, and I've read it 4 times. It's 280 pages, lots of nice footnotes and cross references. And it makes it abundantly clear that in New Hampshire, in the circuit court, the rules of evidence in this book are at the total discretion of the judge. The judge may choose to honor one of these rules or not. And the book gives the reason why that is, because the judge needs the discretion to make things, in his or her opinion, to be fair and good for everyone. The question is, however, does that take place? And according to some testimony that we've heard, some people believe the judge in his or her case was way too broad in admitting things. Other people indicated the judge was way too restrictive. Still, other people believed that the judge was restrictive towards men but not women, and other people believed it was women, not men. So the question is, what should we do about rules of evidence? The two bills before us lay down blanket statements telling the judge exactly what to do. This is the case in Vermont, and we have learned that in Vermont, according to their rule of evidence 1101, family cases are not accepted, that the rules of evidence apply literally in Vermont. It is totally the opposite. The difficulty comes in that about 80% of the cases heard in family court, one or both litigants are there pro se. That is to say, they are representing themselves, they are not lawyers. Some of these are very well read in law. Most of them are not. And so when something comes up, for example, the judge rules a piece of evidence in, and one of the litigants does not like that, many times the litigant does not know what to do. Or the litigant will much later in the trial say, oh, I object to that. In the rules of evidence in New Hampshire, objections must be made as soon as possible. As soon as the judge allows a piece of evidence in, the other side protesting should say objection. Secondly, the other side must give a reason why that piece of evidence should not be admitted, other than just, I don't like it or it hurts my case. Many people who are pro se do not know that, what to do. There are many other places where rules of evidence that a judge may use may be confusing or not known to a litigant going pro se. The same, by the way, is true if a judge decides not to admit something into evidence. Objection must be immediately made and the reason given. In fact, if this does not occur and the decision of the judge is appealed, that piece of evidence not admitted cannot be admitted in an appellate court. It's too late. Or if you wanted that piece of evidence stricken and do not object, and now it is in the appellate court, it's too late for that as well. So the question here is, what do we do, especially when it seems perhaps a judge is going too far one way or the other, or is tipped into an imbalance? Should we, like Vermont, just require everything in this book be done by the judge? Or should we keep it as it is now, but find a way to address the concerns that many people have raised? So that's my sort of opening salvo. I've pretty much said this several times to the others with me. So with that, I'll shut up and just see who else wants to speak. Yeah, it'll warm the room.
Yes, I agree. I believe that we're on the right concept right now, or the right rules of evidence. However, tweaking something to balance the scales may be something we look at. As far as 475, it requires all evidence be presented. And then it asks for what evidence is not presented to be a reason written. So it sort of conflicts with what it first states.
Move closer to the mic.
Sure.
We're frozen.
Yeah, so it sort of conflicts from the beginning, where everything will be presented, to the starting in line 6, where the judge needs to write a reason as to why it wasn't admitted. So I'm not sure if this is a correct avenue to make any fix.
Representative Gregg.
Thank you, Mr. Chairman. And thank you all for being here today. I know it's cold in here. You know, I'm conflicted on this just because when we say something, you know, I've known quite a few people that have had their own court cases and stuff, and it's always hard whenever we think something's pertinent, whether or not, you know, the overseer of the situation also thinks it's pertinent, because it's all up to individual, you know, your own perception and stuff. I think we would have to think long and hard before we start to, you know, encroach on the judges in a way that the reason they are in the position they're in is to be able to, you know, see things impartially. Now, in cases where we have judges, and I know that these are not the norm, right? These are not the majority of what we're seeing, but the ones that we are seeing where there's, you know, a lack of what we say discretion. Maybe we have, it looks like moms are getting more favor or fathers getting more favor, whichever way. There are other states, Illinois being one, that have kind of like a judicial, kind of an oversight, where they do have almost like when you're a student teacher, you have the principal kind of come sit in. They do have somebody that comes and sits in and observes. You know, we've talked about this before when we talked about the recordings being turned on and off and all that. I also want to be very cognizant of the fact that when we discuss how much evidence we're going to make, or, you know, if we're going to decide that we're going to tell the judges to take in all this evidence, the amount of time that that's going to take. I know that there are certainly litigants that would love to, you know, hold up a case and give months and months and months of hearsay and all these other things. So, you know, saying that they just have to take all that evidence in would bog down our already very busy court system. So I just want to think about those things when we're thinking about, making some kind of legislation or whatever. But I do not think that either one of these bills hold uh, a best case scenario for our court system or for any litigants.
Anyone else up front? While they're thinking of something, the five of us are this work group in children and family law, because the five of us up here are also on the special committee for the Family Division of Circuit Court. The clerk of the House ruled we could not have a joint meeting. So what I've told the five of us here in the Children and Family Law Work Group is remember everything we said and heard, because we're going to be looking at this very issue in our special committee. We heard testimony on this the other day. So just that was buying some time to see if the people to my right have anything you'd like to share. Representatives Ball or McMahon?
Mr. Chairman,
Microphone.
you say talk too loud to begin with. Now, the thing I have is just in the narrative of what brought forth the particular bill, and I'm referring to is 475 at this point. Is to ensure that the opportunity to provide evidence at the appropriate time is a commitment to respect the rights of both litigants on either side, and that struck me as just in the narrative of the bill that right would not be, as it states, would not be limited to a third party from the two litigants determining what is an appropriate piece of evidence or not, and have so that it would ensure it would be adjudicated in the discussion and presentation before the judge, and then the judge can make the decision, or not can, but makes the decision. And that's why I thought, in my view, I thought that in meeting the challenges we face based on the early testimonies that we heard, is the litigants would have their right ensured to be heard. And I wasn't seeing this. I did not see this as infringing on the authority having jurisdiction, which is the judge. It says to ensure that the authority has the evidence to then determine the jurisdiction. That's what I'd like to offer that as for consideration on 475.
Thank you. Representative Ball, anything?
I agree that I think we need to take a closer look at this through the special committee. I do think there has to be an avenue for allowing evidence, which we do have. I think that what we were hearing, or what at least I was hearing in all the testimony, is that people want to be heard. They want an opportunity to present themselves. And I think when that does not happen, that is when we're having problems in the courts.
Okay. In talking with several family court justices and having sat in on Nashua Family Court, my experience was that the judges were quite open to allowing pieces of evidence to come in, except for a couple of kinds of evidences. And they're both actually addressed in the New Hampshire Rules of Evidence book. One of these is if the probative value of the piece of evidence is less than any, and I'll use my term now, besmirching of someone's character. That's not allowed. You don't bring in a piece of evidence that's basically an attack piece more than it is anything else. Secondly, the judges that I have spoken with are concerned with somebody just churning the case. And there's a couple of references in Rules of Evidence that a judge should not admit a piece of evidence if that piece of evidence does not further the knowledge of the case. If it's repetitive, he didn't pick up Billy when he said on Tuesday, then the next piece of evidence is he didn't do it on Thursday. Well, we've already established a problem. Because to keep churning the case like this with requests for evidence to come in that doesn't help the case one way or the other is what wastes time. And so then this begs the question, is every judge observant of those two things I just said? Do judges bring in pieces of evidence where the probative value is minimal and the besmirching value is great? Does that happen? Do judges keep letting one party churn with more pieces of evidence? And that's where, even if these rules were followed, are they followed? If it says don't do this and the judge is doing this, a bill signed into law doesn't actually advance anything because they're already breaking the law you've got. So therefore, the discussion that some of us have had with the Justice Department was there's a couple of things that we probably need. Number one, we need better education for the pro se litigants. How many pro se litigants know how and when you object that a piece of evidence is allowed in or not allowed in? We were having a discussion beforehand that there are videos you can watch, there are handouts you can have, but the justices I spoke with said, but they can always be made better, bigger, fuller, richer. That may be something we explore in some greater detail in the special committee. Also, the conversation some of us had was, and this goes to the point about that Representative Gregg made about student teachers being monitored. My suggestion was that the judges in family division are monitored more frequently, and in particular, if there seems to be numbers of complaints about that particular judge. I heard certain names of judges mentioned a lot more during all of our time of hearings than I heard other judges' names. So maybe there are a few judges who are way too broad or way too narrow. And once again, how can we keep the wisdom of giving judges discretion, yet rein them in or expand them out or rebalance them if they're outliers? And that, I believe, is best done not by a hard, fast rule that may absolutely be the wrong rule to have in a case across the board, but have more monitoring, more continuing ed. Any thoughts on that, Representative Gregg?
I absolutely agree. I had something to say and then I was like, it went blank. I think my brain
It'll come
froze.
back.
Sorry about that.
That's all right.
I did just look up, I Googled super quick, like what to do, like for state of New Hampshire, it's all here. Like, I don't even know that we always run into the problem though. These are emotional cases, right? They're the ones that we're seeing over and over. And by the way, the judges that we had mentioned over and over are no longer judges. And that's probably for good reason. But because the judicial system kind of has a check and balance. However, I do think kind of observing or having somebody that drops in on courts from time to time where they don't necessarily know that they're going to be there, that's kind of a better way to do it. The forms, I know that and that's something we're going to talk about later today, but I know that they're working on streamlining them. They have made progress on them. But honestly, I went through and I looked at it, and of course I've been to court with other people and stuff before, so I have a little bit of background knowledge, but it really is all here. It's just a matter of the emotions in a case, whether or not you can slow down and look at it and read what you're supposed to do. There are videos on here too. So I think that I just want to be mindful of how many cases we're hearing about versus how many. I don't want to create a bigger problem because the majority of this is going well.
How does one access that? What's the Google line?
Well, I Googled New Hampshire State Court representing our pro se. That's all I did. And then it takes you to courts.nh.gov. And I've done it a few different ways. I kind of look, representing yourself, New Hampshire, and it always brings you to this. And then it takes you to self-help.
Mhm.
And then you got forms and fees, you got videos, what to expect your first day of court. Lot preparing for court. There's a whole section here before your court date, what to do on your court date. Even things like arrive on time. I mean, that's all on here,
To anyone's knowledge, if you file a case and then they get back to you and say your case will be heard on November 14th, is there a statement that says, and in your preparation, you would be wise to access? Because how would somebody not know? They don't know what they don't know.
Well, I do know I observed in Concord, and I do know there they have the computer where you can fill out forms and stuff. They actually had a link to come and look at this. And I did hear a clerk telling somebody too that they could access it this way. I talked to a clerk and asked, what they do if there's a pro se, and they do advise them to go to this. But then of course that's personal choice, how much of that you want to take in.
Judge Mace testified before some of us on specifically rules of evidence. And God bless him, I got in touch with him and I said, give me a big statement on what we're concerned about. And he is stuck in traffic trying to get off the Cape, so he dictated it to a staffer over the phone who typed it out, and then it was sent to me and then to us. But he covers three areas. One is what I think we've been saying up here, that we really do want to keep our judges free to apply rules of evidence as they see fit, because every case is different. And he even mentions Vermont, where that is not the case, and how much difficulty it has for people who are not lawyers to wend their way through the system, where all of a sudden, pick a rule, the other party has done homework and you haven't, because you didn't know. You don't own this book, amazingly. And so now you're caught flat-footed. And how is that fair? And the judge is not supposed to be the lawyer. Sui sponte is not a good legal action. So how do you know? You don't know. The judge can't tell you, well, you should have brought this up. So he said that first. In other words, tweak what we've got rather than replicating what he believes isn't working in Vermont. But then he also added a section on even more narrative and videos and handouts than we have presently, and even louder, hey, look this stuff up, folks, if you're going pro se. And then he also said the Chief Justice, Mr. Chairman, is very supportive of your idea about reviewing judges more frequently, particularly with the assistance of retired judges. We would be happy to talk with you about how this can be done. So I think there is a willingness on the part of the judiciary to recognize they may have a judge who's too broad or too narrow or who is imbalanced. It doesn't rise to the level of this is a bad judge. And yes, Representative Gregg, there are names that were mentioned who we just don't see on the bench anymore. These are good judges, let's say, who do need some in-service continuing education on how to come back into a better norm. Okay, I've just basically said my opening statement, in other words, all over again. Anything else from us up here before we go to particular bills themselves?
Yeah, I recall, I believe it was Judge Lemire, was it? Or Lemieux?
Lemire?
Lemire, who said there is some evidence that I'm not considering. Because, for example, if somebody badly characterizes the other party and the judge isn't buying it, she's not looking for evidence to defend yourself. So I'm going to say no. And I could see a party getting upset saying, hey, wait a minute, this is, so I don't know if the judges could tell, could say at that moment that, yeah, as far as your character assassination, I'm not considering that. I don't believe that or whatever the judge would say. So that would, because I know if somebody badly characterized me, and I went to put into evidence to support my character, and the judge wouldn't allow it, I'd be upset because I'd be assuming that she's buying the other party's bad characterization of me. So that was another thing I was thinking of is of those that we're calling upon, weren't allowed to give evidence. Were they assuming that the judge was buying the opposition? They're the other parties, whatever the other party said. So I don't know if a judge can say, that's not in your character is not in question for me. So I'm not going to take evidence supporting your character because it's not what I'm considering right now.
Representative Gregg, you have a judge in the family, and I'm sure this sort of thing has come up once or twice.
I do have a judge in the family, and I've grilled him on certain things, but also I used to watch him in court. I do know just from he was not here; he's in Illinois, so I like to focus on what we've got going on in the New Hampshire courts. But the judge that we observed did say, when they weren't going to allow evidence, like this is why. Like she was very good about explaining why or what. I will say also at courts.newhampshire.gov, you can also just Google rules of evidence, and they have it so you can just put in a keyword. So say you want to talk about stalking, say you want to talk about something else. You can put that in there and see about the rules of evidence. There are cases where, especially in cases of domestic violence, domestic abuse, there are certain things there's a big push that you see that they want to have brought in, like maybe the aggressor might want to have the mental health history brought up or something like that. And so that's things that we're generally seeing that no, you can't. I know one of somebody that's testified here and shared some of their work that was, kind of something they wanted to. Those are things that can't be brought up. And I do hear the judge saying that's not admissible, because we can't bring up this or whatever. So I do think there's that. And I want to be cognizant that everybody that says, hey, they're not listening to me, that's exactly the perception. That's your reality and stuff. We've had people come in here before that I thought, man, that person was so aggressive. I can't believe that. And then I went back and watched the YouTube and I was like, okay, maybe that was my own bias hearing that a little differently. But it's hard to come out of that and really watch and see what's happening because these are high emotional. I mean, these are very important cases and everybody's evidence is very important. But once again, there are ways to look up rules of evidence without having that book that you actually don't have to read through the entire thing. You just put a keyword in and see what those rules are for that particular thing.
It might be helpful at the last two lines of House Bill 475, which is if evidence or testimony is not admitted, or we could even say is admitted over the objection of a litigant, the reason should be noted. That might be helpful to diffuse some people thinking the judge is biased against me. I'm just, throwing that out as a possibility. I did watch a moot court trial where the litigant was bringing suit and against the respondent for breach of contract. And the litigant wanted to exclude the respondent from describing in her own words things, but instead stick only to the contract that was allegedly breached. And in one moot court rendering of this, the litigant said, I would like to give 3 examples of how this person cannot be trusted. And the judge said the probative value of that is exceeded by this, again, my word, the besmirchment of character. In another rendering of the same moot court case, the litigant bringing suit said, Your Honor, for the purpose of this, I wish to bring in a piece of evidence where unemployment appeal indicated by the person presiding that the individual wanting unemployment payouts was self-contradictory. The judge allowed that because it didn't besmirch character, but oral testimony could be impeached by the track record of the person in a similar thing. I'm going to go to law school, darn it. I'm really getting into this. So there's an example where I never knew that until I watched this. I never knew that until I read this book 4 times. And if the judge simply said, no, I'm not admitting it, I'd want to know why. So maybe there is something to suggest in our special committee discussions with the judges. Should the reason be noted in the record or not? I'm just throwing that out as a possibility.
Yeah, I could agree with that. As long as a judge doesn't have to review the testimony, the evidence. The example that I gave of, the judge saying, I don't want that evidence of your good character because I'm not weighing in on that. I think you're of good character, so that's not an issue. Then I could note I didn't receive evidence on character because that wasn't an issue in my judgment. But as long as a judge doesn't have to review the evidence or testimony, which if for any reason evidence or testimony is not admitted, the reason shall be noted in the record. So
You like
That's
lines
simple.
8 and 9 of Representative Post's Bill 475.
yeah,
Yeah, I do
actually it's the
too.
amendment.
The amendment, yes.
Did we weigh in on the amendment in committee? I don't recall. We did get it, obviously, because but yeah, I like the amendment much better. The words at the end of the amendment is much better than the original.
But the difficulty about the amendment to 475 starts on line 6. The presiding judge, etc., shall follow the New Hampshire rules of evidence when admitting such evidence and testimony. So to me, that's not good for reasons we've been discussing. But what follows is good, in my opinion.
Yeah, I was just specifying
Right.
line 8 and 9.
If we somehow could extract line 8 and 9 in what we do in special committee into our recommendations, and that could be a point of further discussion. I mean, the judiciary is really, really indicating they want to work with us on this. They see that there's a concern and they want to alleviate it. Yes, Representative Ball.
Thank you, Chairman Pearson. I guess I just needed a little clarification. Representative Gregg, maybe, I'm not sure if I misheard you. You said the aggressor wants a mental health evaluation. I'm not exactly sure what you're referring to. you.
This is so on a specific case, but we'll keep it confidential. But anyway, in this, and I've seen it multiple times, but if you have let's say an abuser, not just aggressor, but one of the things that happens is you might have the victim or the survivor has been to some kind of like psychiatric help. That's not unusual, right? Because they go through depression, they go through denial of, kind of the mental and the emotional stuff that comes with that. So there's something there, like, they're trying to kind of deal with life. Well, an aggressor will use that as a weapon to say they're unstable. They shouldn't have the kids because they've been to this mental health. They don't even necessarily know what's in there, but it's another way to weaponize that system to put that person in a more vulnerable position. Because obviously you talk to, a counselor or something about very private details, right? And sometimes maybe you've talked about your abuse, sometimes you talk about other things, but to then say, you know what, the other person say, I want this as evidence. I want all these records opened up and I want it in there. It's a further abuse and it's a further manipulation of the situation is what it is.
So I guess that's where my confusion is, because from the people that we were hearing from, there were cases where the person who filed the DV complaint was actually the aggressor. And So, and they were using the court to weaponize.
Yes.
And that's where I get concerned. So how does a person who's now been accused of DV, how do they fight that, especially when it starts coming into child custody and temporary orders? And how do they bring forward evidence to say that maybe the person who actually filed the DV does have mental illness, and this is part of their mental illness, to bring forward this type of retaliation or aggressive behavior toward who is actually the victim? Who's being accused. So I think that's where I'm just concerned when evidence is not allowed to show that the person who's being accused has actually been the victim.
Well, I think that if you have a victim saying, you know what, I'd like to fillet it all out. I'd like to show you to prove my own, or that I'm not like this, or that's a little bit different than somebody coming up and saying, hey, I want you to do this. I mean, that's one of these situations that's really hard. And I think that's when we talk about, in our committee, we've talked about the training of judges and stuff to really look at this, because it is a very challenging situation. And it is a statistical fact that many abusers, if not most, will actually say that they've been abused in some way or another. And that's their perception. They didn't get their way. They didn't get anything else. So it is a challenge. But these are the types of evidences that you're seeing, it's kind of a hearsay, or it's a breach of HIPAA or anything else that they're wanting to have this evidence in. And that just, that has to be up to the judge's discretion and stuff. And I get your point that, so somebody's been accused, it is hard to prove one way or the other, but there are avenues, within the rules of evidence that you can actually do that. But it's a matter of being able to, kind of look that up and see that there are some things, text messages, those can be admitted. If you have the actual, it has to have like the full text message, that kind of stuff can be admitted. If you have, let's say, a voicemail from that person, that can usually be admitted, something like that. But there are sometimes some kind of patterns, but it can be very challenging. In a lot of cases, people, if they can, will submit to, either psychological tests of both parties or personality tests or whatever. So it is a challenge, but it's also not the norm. It's not the major cases.
Character evidence is Rule 404. And having read through not only the law, but the reporter's notes, which gives commentary on case law, which is the second level of law, it's very nuanced, to say the least. To be admissible under evidentiary rule governing character evidence, two requirements must be satisfied. Proffered evidence must be pertinent, that is to say, it is relevant to this case. It must constitute a character trait. But then there are other times when just because somebody stole in the past doesn't necessarily mean they stole this time. And it's, past sexual behavior, for example, is generally not admissible to prove a particular thing, but sometimes it is. So that's why on some cases, pro se may not be the way to go.
Yeah, that's
Mike.
sorry. That is the dilemma, of course. And that's why we do see that certain advocacy groups and stuff will provide legal representation, or there's, other ways to do that, because these are incredibly complicated, and it's your life on the line. It's one of those situations where, to have people that are actually trained in this, that have gone to school for this, is the best option. There are advocacy groups for that. And some people can afford it and they choose not to do it anyway. So it's a dilemma.
Yes, Representative.
Thank you, Mr. Chairman. So my concern, we're hearing about the domestic violence that has actually happened. It's the false claims, as Representative Ball says. That's of concern because now it's your children. And I think given a reason has to not let in some character positive information, give a reason, and then the judge would have to give a reason, especially if they found that there was a potential for domestic violence. You know, and that's the issue. And I don't know, in domestic violence, is it an automatic criminal case, or it could just be
No.
litigated in family court? And it's okay. So would a
There's part
family
of it
would a
that's handled
family
differently.
court say that yes, we believe there's been domestic violence? They'll make that statement.
They could.
They could.
Representative Katab and I have a meeting with the speaker later this week about a bill she's filed where domestic violence cases should go, because I've heard conflicting desires. That is, automatically they should go to a criminal court, or because they're interwoven with a family court issue, they should stay. So that's something that I think some further discussion is going to ensue when Representative Katab's bill progresses through. Yes, please.
So many times those two, I've heard a lot of discussion in domestic violence. By the way, the domestic abuse violence, that's kind of an undercurrent of a lot of what we've been seeing and stuff. But on those domestic violence cases, you know, whether or not it should be, you know, handled in the family courts, whether or not it should be criminal, there are times when there'll be a finding of abuse, but the level is not that it's going to push to criminal, or maybe it was the first time or whatever. Those are constantly interwoven. And sometimes in the family courts, something gets missed that then when the criminal hits, they go back and revisit, you know, visitation or whatever else. But it is challenging. I could speak from personal experience. It is challenging when you're looking at waiting for investigations to happen for the courts. But for the family court, what they can say is they can look at like DCFS or whatever. There'll be investigations. There can just be a finding there. They turn in the recommendation to the authorities on charges that then have a different preponderance of evidence. But on that first one for the family courts, when you're looking at the immediate safety, it's much quicker for just to say that there was a finding, and those are investigated. And can those be turned around? Absolutely. But they are done by experts and they're looked at. But it is important to have the distinction between the two courts, and it's important to have them in both courts.
Representative Ball.
In the case that I observed with the DV case involved, the judge was not taking into consider evidence unless it was brought up by the person who was making allegations. So it wasn't so easy to just put in text messages or anything. There was no evidence being accepted. My concern is that when you're accused of DV, there is no way to defend yourself if they can't get the evidence in, or if they can't question the mental health of the person making the allegation. So I'm just worried with the bill that I just believe it needs a little bit more work. I think that there needs to be some caveats. If there is DV involved, I think that there has to be allowed to have evidence brought in. People have the right to defend themselves against, these are only allegations. And from what I'm hearing, when police are called to the house, somebody is getting arrested. They don't investigate it there. They just make an arrest. And that is the way it is happening these days. And I think it's difficult. You say that there's help in the courts. There is lots of help in the courts for the person that's going in and claiming domestic violence, but I don't see help in the courts for people who are accused of it. There's no one to walk them through the system to figure out how to defend themselves. They're often forced out of their houses. They lose all their money. They lose access to their children, and they need help. And I think that comes down to the forms. It comes down to education, but it also comes down to evidence, and they need to have the right to present evidence in the court. So I'm not saying all evidence has to be, but I do think when it pertains to the domestic violence, I think it does need to be allowed to be in the courts.
Has anyone up here read Representative Katab's LSR on domestic violence? I'm going to take that as a no. I'm going to take that as a 4 no's, 1 yes.
I think she's
And-
still working on it. She's still working on it. I saw
And
the original.
The
but
reason
she's
I'm mentioning that is if we say in general, requiring judges to follow strictly rules of evidence is wrong, in our opinion. Might there be a carve out for DV cases? And that would be perhaps the subject of her bill? Representative Long.
So my question would be, if that were the case, would the judge rule on whether there was a finding that there was domestic violence or there was not? Does that require this family court judge to rule on that?
I don't know. Don't know. If it is brought in as evidence and that evidence then is persuasive to the judge for the larger question, I would say he is de facto ruling on it unless it could be argued that he would have or she would have made that finding anyway, irrespective. I mean, it's for that reason where admissible errors are not appealable if it is ascertained that the verdict would have been the same anyway. How are we doing over there?
So are you talking about the one about the coordinator for high conflict?
I'm not quite But it's certainly something worth exploring somewhere that if we simply keep status quo ante in terms of rules of evidence do not apply in family division, there may want to be a separate carve out on DV. Because that's where the possibility of subconscious bias on the part of a judge might be more likely. And I say subconscious.
I agree with that, Chairman Pearson, and I do feel that that is the area of the family court that is being weaponized. And that's why we need
I
to
would
make
agree.
sure that everyone has equal access to defending themselves against allegations.
Are we ready to start moving to the two different bills before us? I'm going to take 475 because we've been kind of discussing it anyway. And I don't have 475 in front of me, but I do have the amendment in front of me. Would somebody like to make a motion on 475?
So if I may,
You may.
um,
The amendment, I think.
correct. Well, actually, I was gonna, because we're recommended to the full committee.
Yeah, this is a recommendation.
So I would recommend to the full committee that on Amendment 2023-1016H,
Mm-hmm.
that beginning line 8 and 9 be reviewed by the full committee. If for any reason evidence or testimony is not admitted, the reason shall be noted in the record.
So that's not an OTPA or ITL. It is a suggestion, which is fine.
Correct. Yeah. Do we need to?
I don't think so. I mean, this is a work group and we're working.
And if you
and-
want, I could bring that motion forward, I can bring that amendment for the full committee to, or would you want Representative Post to?
Is it the general view of the five of us that the lines, final bit of line 8 and all of line 9 are good, but the rest of the bill not? You don't have the amendment?
No.
Okay, well, here's the amendment. We've been talking about the very end of line 8 and all of line 9, talking about judges giving reasons if they rule a certain way that's objected to. what's above it is just generally saying they got to follow the rules of evidence, and I think we all don't go along with that. So we have a suggestion on the floor that we bring our conversation 8 and above, no, 8 and below, yes, we like. Is that all in favor? Please nod.
Yes.
Nod. Representative McMahon? Okay. All right, I'll write some language in here to that effect. Righty. And where can you get a copy of the amendment? Well, you can, if you very nicely ask
Christina.
our committee researcher.
Christina, could you possibly send us the amendment for, just email us again the amendment on 475? You don't think you have it?
I have, is there a copy machine?
Is there a
close by?
copy? Could we copy it?
Yeah,
It's 2023 -0, I mean -1016H.
Yeah, I don't.
okay. So Representative McMahon says no, but I believe there's a copier down the hall. Would you be so kind? How many do we need? I don't know. Yeah, while you're up.
I volunteer to get up and move around.
Oh, okay, all right. Under the next bill here, 499, there is an amendment 619, but I list it wasn't presented.
Actually, I wrote on mine, so I think it may have been discussed, just probably not. voted on.
Yeah, I wrote on it too, on mine too. On the next bill, does everybody have amendment 619H? Nope, so we could use copies of that,
Yeah,
so.
I'll get her, I'll have her. get us copies of this. Down the hall. Finance.
We should all go meet in the coffee room. Um,
Do you have both amendments?
do you have both amendments?
I do, yes. If everybody would, up here, would please read over now for, whatever it is, the other one, 499? And the amendment. Avon calling. Just, okay. Representative Long.
Thank you, Mr. Chairman. So I think the first section, respondent believes will have favorable to his or her case.
For the record, this is Amendment 619H to House Bill 499.
Yeah, actually, the original, this changes the statute. It's 169C12, not the 490 that was in the original. So that tells me there are some times when respondents will put in evidence that's not favorable to them. I don't know if that's ever the case. Okay, and then in section 2, it appears that I think it's going to be complicated to tell the judge that you shall admit evidence, and then say if the judge has reason to believe that applying the rules shall adversely affect the case, he could waive the evidence. I think that becomes more of a conflict, sets up more of a conflict between litigants, because now you shall admit, and then it's saying, however, if you believe that it'll adversely affect the case.
In other words, you do what we tell you except when you don't want to.
Well, exactly. It's not clear to me. It opens up for more arguments, for more conflict, in my opinion.
You may remember, and I only remember because I wrote it down, Judge Head, who was the link from the judiciary to us at the time, saw sections 1 and 2 to be contradictory to each other. And you agree.
Okay.
And I agree.
Yeah.
And you agree.
And I think where any other bill we're addressing, noting in the file the rationale for not allowing, and I think that's fair.
Yeah. In other words, here, line 15, the judge may waive the rules of evidence and shall note in the file the rationale for this decision is very similar to what we just saw and what we are going to recommend to the Children and Family Law Committee as a whole. So what do we think?
Well,
Representative Gregg, would you like to make a motion on Amendment 619H?
Sure, I'd like to make a I'd like to make a recommendation to the full committee that we ITL this.
Okay, and
second.
Now, do we have to do the bill as unamended? I don't know what to do next here. I always get these backwards.
Well, we're a subcommittee, so we're really a work group, so we could pretty much do
We
what you
can
want.
do what we want.
No, that's right.
So we recommend the bill and the amendment ITL. Firsted, seconded, all in favor.
Aye.
How about my folks to the right here? We have a motion on the floor to recommend ITL. You got to vote. ITL no or ITL yes? Do you like it or you don't like it?
I'm going to say no.
Representative
sure.
McMahon.
Yeah, I'm no on ITL also.
Okay, so and the chair votes ITL. And so that makes the vote 3-2. We recommend ITL. I would be interested as to why you would say no to ITL, because then you're telling me you like this.
The issue is, what are we doing here in the first place, Mr. Chair? And that's because you have the judges doing selective enforcement of what rules of evidence are.
Okay.
Now, that being said, we need, when I say we need, the system should allow the, as you have clearly pointed out, the litigants being given the opportunity to provide their evidence.
Mm-hmm.
Now, that being said, now we're saying what evidence, how it's stated,
Mm-hmm.
and then adjudicated after it's been submitted. That's why, for myself, this is, I'm recommending this to the committee to further discuss. And this is what I'm after, is to have more application discussion on, like the case here where the judges, it's going back to what, I believe brought us here in the first place, is where the judge is stating on his own, on his or her own, whether the rationale for a decision not to follow the rules of evidence.
Okay.
Now, that's taking place now without it being in black letter. It's just the ambiance of the environment, not the statement of how you can expect it to perform, and it being the court. So but that's why it was not for ITL. I want us to do something versus not on this effort, and that's providing voice to both on both sides. But the judge is still there to have a fair application of acceptance of this with something written for a course of rule.
I guess the reason why I didn't have any trouble killing the amendment/bill is the idea of the judge giving reasons for decision was already discussed and agreed to under 499. And that would be part of what we recommended going forward to the whole committee. In other words, line 15 is fine, perfectly fine. It pretty much replicates line 9 in the previous amendment.
But did I misunderstand, Mr. Chairman? You said to ITL both the amendment and the bill.
Mm-hmm.
Okay, now that being said, then it's, as you stated earlier, it's moot to use the word in the right context.
Mhm.
And I'm saying that like I'm for what you just stated, is that the case? Well, then where does that reside? Because they just said the ITL the bill twice. I mean, twice meaning the bill itself. and the
Where,
amendment.
Representative Long.
Yeah, so in 475, we're asking the judge to give a reason why evidence wasn't submitted. In
Or he ruled
475,
against.
the first one, we're in agreement with that. The first one. So 499 replicates that. Well, actually, section 1. The only difference there is whatever the respondent believes will be in their favor. I don't know if I would put in any evidence that would harm me. So I don't know where we need that. They want to put in evidence that is favorable to them. So that's, to me, a no-brainer. I get that. I don't know why you need that in language. And I think it creates complications, and creates more of a conflict down the road. So then 80% that are minimal conflict, that has a potential of creating more conflict with that 80%. Again, we're talking about the 10-15% of conflict cases.
What would you think if we took House Bill 499 as a vehicle and admitted Section 1, Roman 1, and capped Roman 2 if the judge has reasons that applying the rules of evidence shall adversely affect the case? You could adversely affect the case by having unnecessary further evidence. You could do it by probative value outweighed by besmirching character. Those are reasons why a judge would say, no, this doesn't advance the case. So if we just took Roman 2, the court shall apply the rules of evidence to enhance the predictable, orderly, fair, and reliable presentation of evidence. I think that's in the book somewhere. If the judge has reason to believe that applying the rules of evidence should adversely affect the case, the judge may waive the rules of evidence and shall note in the file the rationale for the decision. If we just kept number 2. If we had an amendment, if I wrote an amendment, ran it over, we all liked it, and it says basically Rule 2, the whole bill shall be replaced with just Rule 2. How does that sound?
Yeah, I have an issue with, I would have an issue with that. Because the judge could only not allow evidence if it adversely affects the case. So if somebody smeared my character and I wanted to submit evidence, and the judge is saying, I'm not buying that person that smeared evidence on you, it's not going to adversely affect the case.
I see. But
Right.
it does besmirch your character.
Right, but the judge isn't buying it.
Okay.
You know,
Alright.
and that would be written down at the end, a decision why I didn't take the evidence, because the character of the of the character of the party was not being weighed in. They're you know,
All right.
I didn't accept that the person was whatever.
Okay. Wait a minute, I want everybody in here. Want to share with us? Yeah, go ahead.
Excuse me for talking.
No, that's okay.
With my colleague.
Just
As a
don't use
freshman-
white out on the screen, that's all I ask, okay?
As a freshman, I just needed some clarification because I'm, again, a little bit confused because this is repealing a different part of the law than 475. They're two separate issues. And I just pulled up the part that it's actually saying it would repeal. And that's where I was just trying to get some clarification, looking at that section of the law. I could be wrong here. That's why I was asking for clarification.
I guess what I'm looking for is something that does not take away the judge's discretion, but adds if the judge accepts a piece of evidence over an objection or denies a piece of evidence, obviously the person proffering it would object, the reasons must be stated. Period. You like that? How does that sound?
If I may.
Yeah.
Yeah, well, Rob brings up a good point. I don't know if was it 499 that changed the statute 490 to 169? Yeah, it did, but 475 addresses 490. So, I mean, we would be looking to get that language of 475 if we were going to go with 499. I don't know if it needs to go into the 490 statute or the 169.
So what I'm reading here is the 169C semicolon 12 that they're talking about, that they're looking to repeal is what is 499. So they're looking to repeal that in any hearing under this chapter, the court shall not be bound by the technical rules of evidence and may admit evidence which considers relevant material. Evidence of prior unfounded or founded reports of abuse or neglect shall be admissible in proceedings under this chapter to establish relevant patterns or course of conduct.
That one's 490.
Anybody?
Okay. 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 And 409 addresses all. Okay. So we would need it in the, so this is the right statute here. Oh.
So they go to two different places in the law.
If I may,
Yeah.
thank you, Mr. Chairman. Yeah, 475 addresses, the amendment, so if we put it in 475, it addresses all, 490D addresses all family court evidence, and 499, changing it to 169C just addresses, you would be duplicating, it just addresses abuse and neglect cases, 169C. So we already got it all addressed in 475.
475,
testimony.
okay. Then try this out. Take out the amendment 1016 to House Bill 475.
Yeah.
We strike, the amendment strikes everything up until just about the end of line 8.
Right.
And what we add or change, in fact, it strikes the whole thing. And an amendment could say, if a judge chooses to admit evidence or testimony and one of the litigants objects, or if a judge chooses to deny proffered evidence or testimony, the judge shall note in the record the reason for this decision. That keeps them free to use their discretion. But if in the admission or denial of testimony or evidence, somebody objects, the judge has to give a reason. Just as if a litigant objects, the litigant has to give a reason. How's that sound?
Yeah, I mean, I think the judge ought to give a reason no matter what.
I do too.
So
But
if
then
we
it goes in the record. And so if you want to collect records and say, Judge Snodgrass so frequently does such and such and gives this cockamamie reason, then somebody could say, okay, here is a unique case where a judge is off base. I would think appeals can be made on error of law or accepted process. You can't just appeal because you lost. Abuse of discretion. And this might help.
So, I mean,
Thank you.
we've already established that pro se's don't object because they don't know
No,
that they
but
couldn't.
but we also
Now we're saying if they object, so if they make a mistake and don't object, there's no note that needs to be placed?
we've already said that we are going to be talking to the committee as of what do we, special committee, that we want to have a conversation with the judiciary
Yeah.
about all of this.
Right.
We've already noted that in here.
Well-
So are we of agreement that we can take either one of the bills and gut it and replace it with the sentence I just read?
I'm happy just the way it is. I'm happy with my ITL on 499 and with the fix in 475. That covers all family
How about
court
you folks over
proceedings.
there who were against this ITL? I mean, we can reconsider a vote if we think now we have reason to.
I'm-
I'm sorry, go ahead.
I was going to say I make a motion to reconsider the previous vote.
Okay, this is where we run out of, I haven't been a clerk in 5 years. Okay, we reconsider the vote on 499. Is that the motion?
Yes, reconsider the ITL.
Reconsider ITL on 499, moved by Ball and seconded by
McMahon.
seconded by McMahon. All right.
So do you need to be in the majority to,
Yeah, if we're going to reconsider the vote to ITL, Then we can come back with a unanimous ITL. We can come back with the request for an amendment. We can do that. We can revote if this passes. So the motion before us
Yeah,
is,
but I mean, I'm asking if a person of the minority could reconsider a vote.
sure,
I mean, it's a work group, so we
it's a work
pretty
group.
much anything. Okay.
So the motion is to reconsider the ITL on 499. The chair votes yes. Representative Long,
No.
Representative Gregg, Representative McMahon,
Yes.
Representative Ball.
Yes.
Now we're reconsidering 499. And my suggestion on reconsidering 499 is that we agree to an amendment that replaces 619, another amendment. And the amendment reads, line 1, amend the title of the bill by replacing it with the following. Line 3, an act relative to admission of certain evidence in family court proceedings. Line 5, amend the bill by replacing section 1 with the following. Line 7, Child Protection Act evidence. RSA 169C12 is repealed and reenacted to read as following. And then that is where the amendment just simply adds what I had written earlier, what I'd read. A judge chooses, then must give reasons for the decision.
But then just utilizing that last sentence on 499,
Pretty much, yeah.
I mean, line 14 and 15,
Yep.
without another word add, just that statement.
If the judge,
Yeah.
if a judge chooses to admit evidence or testimony and one of the litigants objects, I could change the word chooses to rules or decides. Or if a judge chooses to deny proffered evidence or testimony, the judge shall note in the record reason for this decision.
And this is, if I may.
Yeah, go ahead.
And this is only on abuse and neglect cases. 169C.
Okay, 169 is abuse and neglect. Then I've got it misplaced. I wanted it to be on anything before family court.
Yeah, that would be 490.
That would be
490, whatever it is, and 470. It's already in 475.
all right.
Right?
Okay, so I should have decided to change 475. All right, 475 is the broad one, yes? It's
Yes.
family
It
court.
covers the family court.
All right, thank you for that.
And by stating that, Rep. Long, that would include then DV.
Correct, yeah.
And just,
Yeah.
I want to make sure I'm clear on that as well.
Yeah, anything that's before family division.
Shouldn't we put it in both? Because you have to repeal that other one.
All right, so actually now 499 is back on the table. And the chair apologizes for the confusion.
Okay.
So now we can go back to our recommendation on 499. And it's 499 is only on abuse and neglect. I'm repeating that until I remember it.
So it's putting that last statement into 475.
Yeah,
and
yeah, let's just,
Thereby 499 is for lack of a better word, deleted, with 475 being the one bill to survive, as amended. For the second amendment.
Right. But what was added to 499 in your,
Well, 499, we're looking at the amendments.
does it adversely affect the case? Was that included in your amendment?
My amendment is now going to be suggested for 475.
Yeah, and what is that
I'm sorry?
amendment? What was that amendment?
It's
Starting
still in my,
from the
it's
judge?
still on a yellow pad.
Oh, no, but I mean, was it starting, it was 14 and 15 starting at the judge, or did it include adversely affect the case? Your proposed.
My proposed amendment for 475, and you're on 499,
Right, because you're
is
taking the bottom of
to
this.
take everything out of 475 and
Yeah.
simply replace it with, if a judge refuses to admit or does admit and it's
judge.
objected to, the judge has got to give reason noted in the record. I'm not offering this now on 499,
Right,
and
right. But you
because
want,
the 499 is restricted to abuse and neglect.
correct.
And that's would apply to all cases before family court.
The
The
amendment,
judge would have to give a reason for,
the amendment to 475 applies to everything.
right,
499 applies only to 169. And as we all know from reading the newspapers, the prime sponsor was thick involved in a case that this addresses.
Mhm.
So let's take these things in order. Having put 499 back on the table, reconsider, what do we want to do with 499 as it is before us? With the amendment, yes.
I didn't think we were amending 499. I thought we were taking a piece of 499 and put it on 475.
We ITL'd 619 with the amendment. We reconsidered it. We now have to vote. We have done legally nothing on 499. And again,
I thought we voted
apologies.
3-2 to ITL.
We voted 3-2 to reconsider.
Okay, so
We can go back and do it.
on House Bill 499, if
All right,
Can
you
make a
may make a motion,
I'll move
Representative.
to ITL.
All right, this is re-voting, which we gave ourselves permission to, and that is Representative Long. And do we have a second? I'll second. And that is Representative Gregg. Now, the motion before us is 499. Raw 499 or 619 amendment? Right now, the motion is 499 without the amendment.
Yeah, if we kill 499,
Then the
There's
amendment
no
is
amendment.
moot.
right.
So the motion before us is 499. I will now call the roll, and Representative Long.
Yes,
Yes. Representative Gregg. Yes. Representative McMahon. And Representative Ball. And the chair recommends to kill it. So it's back to where we were. And remember, these are only recommendations to the committee of the whole where we can make our case. Now, we never voted on 475 except to say we all, and I'm quoting, generally do not favor forcing judiciary to abide by rules of evidence, but we do want greater materials to prepare pro se litigants, more explanations of how the rules of evidence work during a trial, and monitoring judges more closely, especially those who seem to be in the extremes for evidence one way or the other. Or we also believe a carve out of the blanket discretion rules of evidence on domestic violence should be discussed by the special committee and judiciary. That's our recommendation. Do you wish to further encourage me to go get an amendment. You can walk down there with me if you want to, so we
Yeah.
have one of both of us. So that's my question to you. Do you like
Okay.
475? A new amendment that will be forthcoming that will read this. If a judge chooses to admit evidence or testimony and one of the litigants objects, or if a judge chooses to deny proffered evidence or testimony, the judge shall note in the record the reason for this decision. That amendment to be worked on by OLS will replace the bill. What's your thoughts? I think we kind of like that. We like that?
Well, I think as far as the objection goes, isn't that current? That if a judge disallows evidence, the litigant could object, because if they appeal, they need to be able to bring that to the appeal.
The litigant may object at that time and must give reason for it.
Right. I don't know if we need to add the objection part. I mean, give reason for it. I agree. Like the last sentence in the amended House Bill 475, actually starting on page 8. If for any reason evidence or testimony is not admitted, the reason shall be noted in the record. That. I'm sorry.
Anybody with a law degree, go ahead, counselor.
It's you.
Counselor.
I think the difference is what Representative Pearson said before, if it is admitted or excluded. Whereas this last sentence of the amendment to 475, it says if it's excluded. So someone may object to something being admitted just as much as they would to being excluded. So I think what you said was more,
What's that? What I said?
what Representative Pearson first
About
said,
being
that
admitted or.
if the judge chooses to admit evidence or testimony or deny, maybe take out if the litigant objects. I think what we're saying is there's also.
Yeah, I mean, I haven't heard testimony from anybody saying, I want to know why he admitted my testimony.
No, I want to
want
know
me to
why he
admit my
admitted
my
her
evidence.
testimony.
All right.
I
Yeah,
objected in the,
Yeah, now we're
and I gave a
micromanaging
reason and I
the
was
judge.
denied. I want to know why specifically. Tell me why. I have.
From what I saw.
This would just require.
So currently, they're not required to give a reason why they're overruling an objection. They're not required. They're not, judges aren't required to give a reason why they're overruling an objection. Are they required, I would think?
I don't think so.
No, but if you want them to put a reason on the record, I think the language that Representative Pearson said would require them if they say deny.
Okay.
Sorry, not listen.
So we are not going to make a specific motion to the committee as a whole on 475, but we've got a narrative of items we pretty well agreed to.
Yeah.
Okay.
Yeah, we have two proposed languages. And
Right.
Let's see where the committee goes.
Okay.
Can you email those to us?
I will.
Thank you.
This is, I haven't been clerk in several years, and I'm doing it the way I did it before, pen and paper.
Very detailed too.
Thank you.
I would not fill both sides of a paper.
Yeah. Okay, I think we're done, folks. And
Very good.
thank you, and thank you, Councilor Lissa.
And when's the next meeting?
1 o'clock for some of us.
Yeah.
And thank you, everyone. And would you like to walk down with me to OLS for crafting an amendment that then could be offered?
Yeah, but I'm not in agreement with that. I'm in agreement with this.
Okay.
So I'll bring this.
Do I have to turn this in to you? To who?